Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are dealing with an investigation that was just completed by a grand jury in Loudoun County regarding an assault that occurred in 2021. This assault got quite a bit of press at the time because it occurred just before the governor's race in Virginia, because governor races in Virginia happen in off years. So they happen in odd numbered years. Unlike presidential election or congressional elections, Virginia does its election in odd number years. So it was a big deal at the time because it was in Virginia. Virginia is a swing state. It was just before the governor's election, so a huge election. And it involved the detail that it involved a person who was transgender, or at least claimed to be, so that they were wearing a skirt and something and attacked someone in a school bathroom. Not the first school, incidentally. Not the first school bathroom, incidentally. They had already assaulted someone in a different bathroom, and then they had been transferred, like a bad hot potato or something. Well, this obviously got a lot of attention at the time, not for least of reasons, because the school initially denied that it occurred. And said that they were unaware of any assaults that occurred in their bathrooms. Well, the assault did occur, and we now have a result of a grand jury proceeding. So let me talk a little bit about the history of this case. As you will see in the description of this case did result in criminal charges against the student who was charged in juvenile court, and some sort of finding was against that person. But there was a dissatisfaction because the school board said it was going to investigate and then didn't release a report. Well, that was not great, so the Attorney General ordered a special grand jury to do an investigation. Grand juries are an old procedure that are used, and a lot of procedures that are now in modern law derive from grand juries. So grand juries have a lot of power, and that power, if you like, has been fractured and spread among different institutions, such as, for example, police, investigators, and prosecutors, and a lot of things. But those powers of the grand jury still remain. And one of their roles is, of course, to indict, so they can bring criminal indictments, and they are required in the federal system for that purpose. But they don't have to result in criminal indictments. They can also be used as investigative purposes, much like a police department. Unlike a police department, however, of course, the grand jury has the power to subpoena. They have the power to put people under oath, and it's also comprised of random members of the public. They are selected just like a normal jury is, selected on the same kind of procedures. And this grand jury did an investigation and released a report. So we're going to do that. We're going to read this report that was released by the grand jury and make sure that all those things are going on. So let's read this grand jury proceeding that occurred in the circuit court, which is the trial level court for Loudoun County, which, by the way, incidentally, I lived in nearby Fairfax County for 15 years. So Loudoun County I'm very familiar with because it was my neighboring county for a very, very long time. Also, incidentally, has very good wineries if you're into that kind of thing. But we're not here so much about the wineries as we are here about the graping. So we are here on a motion for the grand jury to unseal the grand jury report, and that has been ordered. And here is the grand jury report. We, the 9 members of the grand jury operating in the Loudoun County Trial Court, impaneled at the request of the Attorney General pursuant to law to investigate and report on any condition that involves or tends to promote criminal activity, submit this report to the public to document our findings. So they were asked to do an investigation. They were able to subpoena records, right? So they have the power to subpoena. They have the power to documents. They have the power to subpoena witnesses. They have the power to put people under oath. So they have the power to do those things, which in some senses go beyond what the police can do. But that's the nature of grand juries. All right, so let's learn a little bit about why this grand jury came to be. On October the 7th of 2021, the Loudoun County Sheriff Office publicly announced that a teenager had been arrested for sexual battery and abduction of a fellow student at Broad Run High School. Just days later, press reporting indicated the assailant had also committed 2 other counts of forcible sodomy on a fellow student at Stonebridge High School. So not their first assault, not their first time having a problem. And also, incidentally, these are not just schoolroom antics. This is grape. And so this is a problem. So let us make sure that we, I guess, transfer them around from place to place, and don't tell anyone about it, because that sounds like a good thing to do. The assaults in question occurred in the female restroom, or that assault in question occurred while in a female restroom while the assailant was wearing a skirt. So this might be part of the problem because they're part of the LGBTQ plus ampersand upside down question mark movement. And so perhaps their rights supersede the rights of someone who is sexually assaulted. Community outrage ensued, as one would imagine. Many questions surrounded how and why the Loudoun County Public Schools allowed a student accused of the graping of a person's rear of another student to transfer schools, leading to the different sexual assault. Yeah, why not so much with the criminal charges rather than just shuffling them around? Or expulsion, maybe. That might be good. National outrage focused on Loudoun County because the student was labeled as gender fluid. I believe the student labeled themselves that way, and I believe the school administration labeled them that way. The school had recently passed a transgender policy to conform to the Department of Education's model, and an article linking all these facts was published just weeks before the highest profile election in the country at the time, the Virginia gubernatorial contest. Yeah, so Virginia is one of, I believe, 4 states that runs its state election in odd number years. Most states run their elections in even number years along with the presidential election, but Virginia, because it's special, doesn't want to do that and never has. So it does its elections in odd number years, and Virginia, being a huge swing state, of course, gets a lot of national attention. In an effort to quell the public outrage and deflect blame, the school released a statement in October. The superintendent held a press conference in October, and the school released an additional statement in October. I'm sure that made everyone feel well better. In late October of 2021, the Loudoun County School Board agreed to conduct an independent review of the situation regarding the assaults. The independent review was not announced, however, until after the election took place. So the school board okay, we're going to investigate ourselves. So how did that result? Well, on January 14th, the school board announced operational changes to the school system. I'm sure we feel a lot better, purportedly stemming from the independent review, but noted it would not be releasing the review. So we've conducted a review, we're making changes, but we're not going to tell you what we discovered during the review. Thank you, Pat, for the gift memberships, by the way. It is appreciated. The reason that the review apparently would not be made public was due to family privacy, student confidentiality, and attorney-client privilege. I'm not sure necessarily how attorney-client privilege necessarily gets into this, but okay. This caused additional anger from the community that believed the report would be public and demanded to know what they knew and when they knew it. So on January 15th, the governor signed an executive order authorizing the attorney general to investigate. And in April, the court, at the request of the attorney general, impaneled the grand jury to do exactly that. All right. So under Virginia Code, the special grand jury impaneled by the attorney for the Commonwealth is not required to file a report with the court. This is true. They don't have to do that. They don't necessarily have to do anything in particular, because grand juries are an investigative tool. And that investigative tool may or may not mature into any outcome. Just because the police investigate doesn't mean that matures into an outcome. But given the intense and local national public interest in the events leading to creation of this particular body, the members of the special grand jury want to ensure transparency surrounding the investigation and report on some of the findings. While we do not go into every detail that we've learned, we want to share high-level thoughts with the community in an easily digestible manner and provide some recommendation in the hopes that similar events will not occur again. This was almost certainly reviewed by a Commonwealth prosecutor before being authorized for review. So the grand jury may have written it, but I think it was edited and wouldn't be released unless they did what they wanted to. So But members of the grand jury can always talk about their experience, so, you know. The length of the report is reflective of the fact we want all members of the community interested in learning about the events to be able to read so in one sitting, okay? While we do not expect this report to be well received by all sides, just the facts will be fine. The contents herein are an accurate assessment of the testimony received and our collective thoughts regarding that testimony and all other evidence received by this body. We do not hesitate to point out shortcomings of individual or collective actions, and unless otherwise stated, such criticisms should be viewed as nothing more than identifying for the public where breakdowns occurred, allowing such horrible events to take place. Well, I feel free to identify away. Although we heard testimony from more than 40 witnesses and reviewed over 100 pieces of evidence, only certain key documents are attached to this report so the public can have faith in our conclusion rests on solid evidence. But we're not going to release everything. We're only going to release the certain things, not all the things, but we're going to attach some of the things. So, okay. So yeah, the grand jury, by the way, of course, is not a petit jury, which here's a criminal case. The jury of 12 that you hear, a petit jury convicts beyond a reasonable doubt. A grand jury indicts or not based on preponderance of the evidence. And they don't even need a full majority. They don't even need unanimous consent of the grand jury. Typically, it depends on the nature of the grand jury and what it's being held for. But yeah, so this is just what they think is more likely than not, I suppose, about what happened. But okay, let's read this and see what we got. We believe that throughout this ordeal, the school administrators were looking out for their own interests instead of the best interests of the school. Oh my God, bureaucrats trying to protect their own ass. Say it ain't so. Say it ain't so. Say that they weren't trying to look out for themselves and protect themselves rather than what's in the best interest of the school or the best interest of the students. This invariably led to a stunning lack of openness, transparency, and accountability, both to the public and to the special grand jury. So the grand jury is noting that they had to extract teeth on this. But again, they do have the power to subpoena and compel testimony. But there's like, we had trouble getting testimony from people. There were several decision points for the senior administrators, up to and including the superintendent, who I understand has just been fired. So again, we all feel well better, I'm sure. To be transparent and step in and alter the sequence of events leading up to the sexual assault, they failed at every juncture. But they've studied the problem and they've reviewed the problem and they understand all the things that are going on. And Veronica, yes, he was. And I'm sorry that's inconvenient for you, but we're going to continue reading on. We conclude that there was not a coordinated cover-up between the administrators and members of this board. Coordinated, I'm sure, but everyone looking out for Veronica says, no, he wasn't. Yes, he was. Yes, he was. I can keep saying it. Yes, he was. Yes, he was. He was trans. And yeah. Or is this a no true Scotsman fallacy thing? Is this a no true Scotsman fallacy? Well, he wasn't really trans because no true trans person would do XYZ. Proof? We're reading the proof as we speak, Veronica. That's why we're here. Indeed, except for the email from the superintendent, the school board, both as a body and as individual members were deliberately deprived of information regarding these incidents until after the sexual assault. And even then, they learned not from the superintendent's office. All the reporting I saw was he wasn't trans. Oh, I'm sure if all the reporting you said that, it must be true. So he's just a boy wearing a skirt. So he's not trans. He's what would be? He's just a drag king. Whatever. Veronica over here doing cause for the LGBT movement. We also believe that the abduction and sexual assault of a female student at Broad Run High School could have and should have been presented. A remarkable lack of curiosity and adherence to operating in silos by administrators, ultimately to blame for the incidents. Veronica having trouble with facts. The victim never said he was trans? Oh, okay. That definitely is dispositive. While we strongly believe the school bears the burden of blame for the incident and transfer the student, a breakdown of communication between and among multiple parties, including the Sheriff's Office, the Court Services Unit, and the Loudoun County Commonwealth Attorney's Office led to tragic events that occurred. I don't know why you're such an apologist for the trans people, Veronica. This is one of them, and you just have to accept that and deal with it. This is a person who likes to be trans and go into bathrooms that aren't theirs and assault people wearing skirts and all the rest of it. And yeah, the victims were both sexes. I don't know what sex were they of anymore. Who knows the rules anymore? On May the 12th of 2021, less than 4 weeks after students returned to in-person school from the pandemic, a teacher's student at the high school wrote her supervisors about one of her students, the assailant, stating in part, "But this kind of reckless behaviors persist. I wouldn't want to be held accountable if someone should get hurt." So they're apparently well aware the student poses a danger. 16 days later, that student sexually assaulted a female student in the girls' bathroom. For around 3 hours after the sexual assault, the individual was missing and at large in the school. At around 2:15 p.m., the father of the girl who was sexually assaulted arrived at the school. He was very upset to learn what happened to his daughter and became very loud after initially being denied entry into the building. So dad over here, upset that his daughter, has been sexually assaulted by a trans person in a bathroom, shows up at the school and is a little bit angry. Shortly after 2:30 p.m., the father had been escorted from the school, but the individual who committed the sexual assault was still at large in the building. So the father is being thrown out of the school, concerned about his own raped daughter, but the trans individual who committed this assault is running free in his skirt, unaccounted for. During this time, the Stonebridge principal reached out to the superintendent's office about getting a no trespass letter against the father. So they wanted to trespass the father for coming to school to deal with his daughter being raped by a trans person. And they're like, let's throw him off school and prevent him from coming back because he's a little bit upset about things. The school's chief operating officer arrived at the school that afternoon and talked with the principal. At around 3:30 p.m., he sent an email to the superintendent and other senior staff saying, in full, "The incident at the high school is related to policy 8040. I will set a Teams appointment from 3 to 5 and will log in now and offer an update if you want to log in. Policy 8040 addresses the rights of transgender and gender expressive students." So the incident relates to the rights of transgender and gender expressive students, such as the assailant, apparently. 6 people joined the Teams meeting, including the superintendent and now the deputy superintendent, who I suppose is now the superintendent because the superintendent was just fired. We believe the Teams meeting was the beginning of the complete lack of transparency surrounding the situation. Shortly after the meeting ended at 4:10, the superintendent sent an email to the school board alerting them of allegations of the assault. At 4:46 p.m., the Stonebridge principal sent an email to the community about what occurred at this school that earlier that day, namely that a trans individual had assaulted a girl in the girls' bathroom. The email neither mentioned nor hinted at the sexual assault that took place in the bathroom, instead focusing on the father of the victim who had arrived at the school. So again, it's the father who's upset about his daughter being raped by a trans guy who's the problem, not the trans person. We have our focus on the right place. The email was drafted by the public information officer and ultimately edited and approved by the superintendent. At a July 22nd, 2021 meeting at the school board, the superintendent, in response to a question, stated, "To my knowledge, we don't have any records of assaults occurring in our restroom. We," this is now the grand jury speaking for themselves, "believe this statement was a lie. We believe the superintendent was in fact lying at the time." The superintendent later claimed he was viewing the question in light of the policy. So, do you have any knowledge of assaults occurring in your restrooms? No, because I'm viewing my answer in light of the policy, which requires our tolerance to the trans people, such as the assailants. Per the aforementioned meeting, we know the superintendent learned shortly after the incident that the assault was related to the transgender policy. On July the 2nd of 2021, 2 petitions, arrest warrants for juveniles, were issued against the students for 2 counts of rape pursuant to the May 28, 2021 assault. As required by law, the court services unit notified the superintendent of the petition. On July the 8th, the student was detained, but per state law, he was released on the 22nd. As part of his release, it was conditioned that he could not return to the one high school, but he was transferred to a different high school. So, on July 2nd, we issue an arrest warrant for the trans child with the assaults. We arrest him and we detain him. Pursuant to state law, we release him, and then we transfer him to a different high school. While he, she, it is facing charges of sexual assault, rape, and all the rest of it. In early September 21, 2 female students at the high school enrolled in an art class with a former student approached their teacher, asking to be moved away. The former student made them feel uncomfortable by the way he, she, it was behaving, because he had discovered where their friend group was hanging out and following them around. The art teacher reported these events to the Broad Run principal, who had failed to inform the teacher of the connection to the events at the high school or that the assailant was a recent transfer. So the teacher was unaware that the student had been transferred from a different school and was facing charges relating to rape. But they were in school all the same. On September the 9th of 2021, just 2 weeks into the new school year, the individual grabbed the shoulder of a girl really hard and kept tapping her head with a pencil during class. He tried to take the girl's Chromebook and asked her if she ever posts nudes online. He then asked another boy if his grandmother had posted any nudes online. Okay. The superintendent, deputy superintendent, and superintendent chief of staff all learned of the incident and knew it was the same individual who committed the sexual assault at the other high school. So the superintendent, deputy superintendent, and the superintendent chief of staff all learned about this incident, asking the student if she ever posted nude online, asking another boy if his grandmother ever posted nudes online. They all knew about it. But yeah. I'm going to keep saying whatever the hell I want. And if anyone has a problem with that, they're welcome to leave. How about that? Despite having a 12-page disciplinary file, wearing an ankle monitor, being closely monitored by the broad-rim principal, knowledge of this incident by the highest administrators in the school, and suggestion by court services unit that a more serious punishment be given, the individual received nothing more than verbal admonishment. So they received a strict talking to. Despite already being on charges, an arrest warrant has already been issued, and they spent time in juvenile detention relating to assaults at a prior school. We're now at a new school, asking the student whether or not they ever post nudes online, asking whether or not another student has his grandmother, whether or not she posts nudes online. And we've responded to this by a stern talking to of don't do it again. It's going really, really well over here. I can see. Despite having a 12-page disciplinary file, wearing an ankle monitor, being closely monitored by the broad run principal, knowledge of the incident by the high administrators in the school district, and suggestion by court services that a more serious punishment be given, the individual received nothing less than verbal admonishment. So they have an ankle monitor, and court services suggested something more serious, but still the verbal admonishment. Less than a month later, on October the 6th of 2021, the individual snatched an unassuming female out of the hallway, abducted her into an empty classroom, that's what we call kidnapping children, nearly asphyxiated her, and sexually assaulted her. The individual was taken into custody that day, where he has remained ever since. He was charged and convicted in juvenile court, but probably not that serious charges because, yeah. Given facts learned throughout the investigation, multiple witnesses testified that on October the 6th of 2021, crimes should have been prevented and expressed disgust, outrage, and sadness that they occurred. We asked the broad run principal whether he felt any responsibility for what happened to the girl who was abducted, but he did not after his attorney objected and mentioned the Fifth Amendment. So, covering their ass. All because of this policy. The school district says it's because of their policy. They say it's because of their transgender and inclusive student policy. They want the transgender and the sexually fluid students, like the assailant, to feel comfortable and wonderful and welcomed and everything. And it's really, really important the transgender and the sexually fluid feel accepted at not one high school, but two, mind you, even after the repeated sexual assaults with the sodomy and the kidnapping. So here is a summary of the investigative findings. On May the 12th of 2021, only day 14 of the in-person school for the year, so it's going really well, a teacher's assistant wrote a fellow teacher and her department chair regarding one of the students in the study hall. Good afternoon. Even though he seemed to start the year very well, and though he gets along with the peers, he seems to have a problem with listening and keeping hands to himself. He has come into class more than once with his arm around a girl's neck. I have caught him sitting on another girl's lap several times. There doesn't need to be a global pandemic to say this is unacceptable. I mean, yeah. I mean, personal space at all? His refusal and disregard to me and my assistant has us at our wits' end. I understand the school year is quickly ending because, COVID, so it's only day 14 of school instruction and we're already looking at the school year's end. I understand the school year is quickly ending and that students and staff alike are counting down the days. But this kind of reckless behavior persists. I wouldn't want to be held accountable if someone should get hurt. Cover your ass. One of the recipients of the email did not know who the student was and felt like it was misrepresentative to her. She testified she had nothing to do with the student and did not follow up or discuss it with anyone because he didn't want to invade the student's privacy. Yeah, student's privacy, I'm sure, is a real concern over here. Or more of the point, it's just a shield we can hide behind. You know, it's just a shield we can hide behind. It's like, oh, it's privacy. Sure it is. Sure it is. The other recipient, a department chair, viewed this email blithely. She testified she was confused because she wasn't sure if the author meant like get sick with COVID hurt or something else, and questioned the true motivation of the author. She did, however, follow up with the student's case manager, who called the student's mother. None of this is documented in the student's file, and neither the department chair nor the case manager spoke with the author of the email about her concerns or what prompted her to write the email. The department chair also mentioned this email to the high school assistant principal, who questioned whether the author of the email had followed proper protocol. He testified this was a classroom management situation, and if it continued to happen, we would escalate that to whatever would be disciplinary referral. The assistant principal, however, testified that there had been other discipline incidents in the past, including this student, and that he had seen him in the main office, but this was the first time that he'd gotten his attention. Again, it was just the 14th day of in-school instruction. While not predictive, the email was a warning. The student, that would be the transgender one, had already caused enough behavior disruptions to himself on the principal's radar, but rather than trusting the word of a faculty member and asking her directly about the concern, no party to the email treated it with the seriousness it deserved. The situation should have been elevated. It should have been documented. Someone should have spoken directly with the student. None of that occurred. 16 days later, the student, the transgender one, sexually assaulted a female classmate in the girls' bathroom. So we've gone from in our continuing escalation of things to assaulting kids in one school, dragging them into a classroom, attacking them in a bathroom, and all the rest of it. The May 28th incident. From 11:46 a.m. to 11:59 a.m., which is 13 minutes and a pretty long time, the assailant was chatting with a female student on Discord, a messaging application about potentially calling a pass to have some fun. The students were using their school-provided laptops to have this conversation, and at least one of them was in class. The two individuals had met in the bathroom 2 weeks before to have consensual sex, but had never had sex outside the high school. So apparently we are meeting in the bathrooms to have consensual sex in the high schools. It's going over super well over here. And now maybe less with the consensual, and maybe a little bit more with the non-consensual. At noon, the two students met in a handicap stall, the female bathroom. The male student, the transgender one, became handsy and then more aggressive, which caused bruising on the chest. The female laid down on her stomach on the floor and had the male put her arms down as he forced himself onto her. While this was occurring, while the rape was ongoing, a special education teaching assistant walked into the restroom while the rape was ongoing. This caused the male student to jump up. The female student was in a lot of pain and got up slowly. And when she was in the seated position, the male student pushed down her shoulders and grabbed her face. The special education teacher later said that she saw 2 pairs of feet under the stall, but did nothing about it. This is just a normal everyday thing. I have 2 pairs of feet under the stall in this bathroom, and this doesn't strike me as odd in any way. that there are two people in this bathroom stall. This is just totally normal. Uh-huh. She testified this was not uncommon because someone could have their period, they might need a tampon, or someone had a boyfriend they had a fight with. Well, you don't want to like go in and deal with that in any way. I'm like, okay. The assailant later acknowledged that they don't usually do anything regarding two pairs of feet in the stall. So the assailant was apparently aware of this. After the teaching assistant left, the assailant again forced penetration against the student, this time orally, and then left the bathroom at 12:24. At 1:28 p.m., the school's high school principal emailed the director of higher education and supervisor of the high school stating, "I have a female student who alleges another student attempted to rape her in the bathroom today. We are sending this to law enforcement. The girl is currently with a nurse. We will address this by the neighbors." This is the same student who transferred here from the other high school for a similar allegation. It is unclear why the high school principal included that last sentence in his email or the relevance to the situation. We need to see no evidence the student was transferred for a similar allegation. The fact that the principal included it, however, suggests he was skeptical of the veracity of the allegation from the offset. So it's not clear who's they're being talked to, and maybe the grand jury is confused, but yeah. At around 12:15 p.m., so this is about 45 minutes later, this is about an hour and a half later, the father of the victim arrives at the school. The school resource officer, who is a police officer, initially denied the father entering the school because he didn't have valid identification. The father called his wife, who was inside the school with her daughter, asking for help to get in. She told the father what they initially thought was an assault against their daughter was actually a sexual assault. This further infuriated the father, I would imagine so, who caused the scene, and the school resource officer, that is to say, sworn law enforcement, eventually escorted him inside the building and then escorted him outside the building. Handwritten notes indicate that around this time, the now deputy superintendent learned she knew of the allegation the victim was anally penetrated and that the assailant was missing. The school resource officer report notes the assailant was not able to be located. A teacher who knew the assailant was pulled in trying to locate the assailant. Emails indicate at this time, this is an hour and a half after the assault occurred, the principal is concerned about obtaining a no trespass letter for the father. The father, who's a little bit concerned about his daughter being raped, is the problem. The assailant was not found until nearly an hour after the email was sent, while leaving the school at dismissal. Given the nature of the allegations, we are dismayed at the lack of concern regarding the assailant being at large in the school for over 3 hours and believe school should have been locked down to find the individual. The school's chief operating officer arrived at the high school that afternoon. Will do, Adam. The school's chief operating officer arrived at the school that afternoon and had discussions with the principal. The chief operating officer testified that somewhere along the line of the conversation during the day, someone had informed me that the incident in the restroom involved a trans man who was wearing girls' clothes. At 3:30 p.m., the chief operating officer emailed the superintendent, the now deputy superintendent, who I believe as of the date of now, as of 3 hours ago, is now the superintendent, the chief of staff, director of communications, and assistant superintendent, stating the following: the incident at the school relates to our transgender policy. So the trans man wearing the girl's clothes relates to our policy on trans people and the sexually fluid. I will set up a Teams appointment and will log in now and update you as needed. The superintendent, the deputy superintendent, chief of communications, and chief operating officer joined the meeting. The director of student services and the high school principal joined, and the meeting lasted for 30 minutes. The high school principal testified that all the staff there wanted to meet with me and hear directly from me as to what occurred that day. No one else questioned about this meeting, however, could recall the contents of the discussion. No one could recall the contents of the discussion, which we view as critical to fuller understanding of why the officials acted in the manner they did. We believe there's intentional institutional amnesia regarding this meeting. Well, people have chosen to forget. Yeah, they don't want to remember. They don't want to remember. After the meeting, multiple messages were sent regarding the incident in the high school. At 4:10, the superintendent privately emailed the school board stating, "The purpose of this email is to provide you with information regarding the incident that occurred at Stonebridge High School. This afternoon, a female student alleged that a cross-dressing trans male student sexually assaulted her in the restroom. The school is investigating the matter. Secondary to the assault investigation, the female student's parents responded to the call and caused a disruption by using threatening and profane language because they were a little upset their daughter had been raped by a trans cross-dressing student who had already been kicked out of one school and arrested and assaulted for assault and now was preying on others. And this language was overheard by staff and students. Additional law enforcement units responded to the school to assist with the parent. Publicly, a different message was sent. At 4:46, the school principal sent the following message. Good evening, Stonebridge families. This is Stonebridge principal Tim Flynn. How you doing, Tim? There was an incident in the main office area today that required the Loudoun County Sheriff's Office to dispatch deputies to Stonebridge. The incident was confined to the main office and entrance of the school. There was no threat to the safety of the student body. Lie. The incident was witnessed by a small number of students who were meeting with the staff adjacent to the main office. Counseling services and services of our unified mental health team are available for any students who may need to talk about today's incident. Yes, the students who might have overseen the angry father, angry that his daughter got raped by the trans person. Students might have noticed the sheriff's office personnel on campus, and I wanted to let you know that something out of the ordinary happened at school today. The safety of our students and staff is top priority here at Loudoun County Public Schools. Yeah, that's a lie. That's just a lie. The top priority is them saving their own ass. That is clearly their top priority in every possible way. They just they want to protect themselves, and they are really, really serious about that. And yeah. All right. Or was I? Okay. The school officials repeatedly cited privacy concerns or jeopardizing the investigation as the reason why the sexual assault was not mentioned. I'm sure that was their real reasons. However, for a school system that repeatedly trumpets the importance of student safety, the school dropped the ball in this instance by alerting the community about the incident. There was a certain way to inform the community about the allegations of the transgender sexual assault without sharing information about any of the students or jeopardizing an ongoing investigation, but the school, to defend itself, chose not to do so. We feel that since the school sent an email about the disruptive parent, they should have also sent an email about the incident involving students, which did pose a threat to the student body, which also required the involvement of the school, but not so much. The sexual assault occurred on the Friday before Memorial Day. When school resumed the next Tuesday, the school had no formal policy for how to handle the situation, so the school came up with a temporary solution which allowed the assailant to remain in school by keeping them separated. They allowed the assailant to stay in school, despite already being transferred from one school because of a different sexual assault, 2 of them incidentally. Despite already committing another sexual assault at this school, we're going to allow them to remain in school, but it's okay because we're going to separate them from the victim. Not that there are any other possible victims anywhere in the vicinity, but it's totally solved. It's totally solved. The following day, the assailant was back in school on his computer, deleting conversations and potentially evidence from Discord. Okay, so those are the events of the day. Let's learn a little bit more. On the June 22nd school board meeting, much has already been written and debated about the school board meeting. Political parties and candidates across the country have used footage and events from this meeting to promote their partisan purposes. Well, the purpose of maybe keeping transgender assaulters out of school would be nice. And much of what has been discussed is factually incorrect. We touch on this meeting for 2 purposes. The father of the sexual assault victim attended the meeting. One item from that evening was discussion over policy 8040, which is the transgender sexually fluid pro-sexual assault policy. The father testified that from what I understand about the policy, they're voting on what happened to my daughter. Something, I might need to check this out. Yeah. He testified that he's planning on just being an attendee and observing. Now, when I did go through that little line, someone handed me a speaker ticket, but I wasn't signed up or anything. I didn't even know what the hell the ticket was for. I'd never been to one before. He emphatically stated he had no plans to speak out the meeting. He later observed an individual accosting and bullying his wife, the mother of the rape victim. He testified the woman told him regarding the sexual assault of his daughter, "No, that's not what happened." A deputy warned them about civility. The father testified the woman threatened to ruin his business on social media, to which the father responded in colorful terms. I bet he did. A deputy then grabbed the father and, after a scuffle, arrested him. The arrest stemmed from the personal altercation and was not directly related to the meeting. That's just a lie, too. The father testified, "I resisted for one reason and one reason only. One, I knew that legally and constitutionally what they'd done was wrong. And I also knew this was my best way and my best vehicle to bring this to light, because for the last month, nothing had gotten done." That's true. So for a month, they had hidden everything. Everyone else had been offered therapy and counselors, but not us. According to Loudoun County, the sexual assault of my daughter had not happened. Later that evening, a school board member asked the superintendent, "Do we have assaults in our bathroom or in our locker rooms regularly?" "I would hope not, but I'd like a class of clarification." The superintendent responded that, "To my knowledge, we don't have any records of assaults occurring in our restroom." The school principal, who attended the team's meeting with the superintendent, testified the superintendent's statement is not true. Another witness testified that the statement was a bald-faced lie. The grand jury agrees. So he just flat out lied. Flat out lied. In the wake of the June 22nd board meeting and publicity surrounding the arrest, multiple school board members reached out to the superintendent asking for information about the assault. On June the 27th, one board member emailed the superintendent stating, "The family lives in my district. At the meeting, the father was arrested. Can you update the board on these allegations and investigation? I understand it would be confidential." The superintendent responded by saying the matter is under investigation by law enforcement and I'm unable to provide an update, and that's pretty much a lie too. On June the 28th, the same board member emailed the superintendent and entire school board saying, since the family has gone public, will there be a statement if someone is arrested for assault? And attached a social media post by the father of the victim. That same evening, another board member emailed the superintendent and the entire school board twice. Once asking, has there been any update on this case that you can share with the board? And again, can you please give us a high summary of the incident that took place at the Stonebridge High School towards the end of May? I realize law enforcement is investigating. However, please share what you can. Please keep us updated. The superintendent responded by saying the matter is under investigation and unable to provide an update, which is pretty much a lie. We have heard testimony that the law enforcement of the school did not see fit to charge or arrest the assailant in the wake of the sexual assault. But the calculus changed after the school board meeting where the father of the victim was arrested, the sexual assault became publicized, and Loudoun County was put into a national spotlight. So the father was basically right. They were on their way to covering this up again. They were on their way to covering this up. They had already covered it up once by transferring the student from one high school to another and not telling, like the teachers, who this person was. But now the school's police officers are like, well, we don't want to arrest this individual. But that all changed when the father was arrested. So Team Dad over here bringing it to light as the school wanted to bury it. Other testimony and documents seem to support this. School officials testified that multiple individuals from the sheriff's office told them the sexual assault was iffy and shaky. How so when a teacher literally witnessed it is beyond me, but okay. Additionally, after interviewing the victim and the assailant, the trans one, the sheriff's office concluded very little additional evidence prior to contacting juvenile intake. For example, certificate of analysis from the lab, a physical evidence recovery kit, and report from the sexual assault nurse examiner did not come back until September. Not that you need that to conduct an arrest, incidentally, but okay. An arrest is based on probable cause. I'm not shaving my head. On June the 30th of 2021, the school provided juvenile intake with its initial report. On July 1st, a detention order was authorized against the assailant for 2 charges. And on July 2nd, 2 petitions and a detention order were issued. On July 8th, the assailant surrendered himself. So 6 days later, nice little period of time there, taken into custody and transferred. For the next 14 days, the assailant spent 23 hours per day in a lockdown. During this time period, the probation officer advised him to use the time wisely and think about how we need to change things so we never come back. Well, maybe less with raping people would be nice. Just a suggestion. The probation officer also noted during this time frame, the assailant had adjusted a little too easily to the experience and doesn't appear to have any real concerns. So basically, they have no remorse. They have no remorse, and they're a psychopath, and they don't care, and the trans thing must win out. The trans thing must dominate all things for all time, in all ways. Yeah. Yeah. On July the 26th, the assailant, the trans one, was released to the custody of his grandmother, who lived in Pennsylvania, for 2 weeks while his mother was on vacation. Well, if this is what she has to deal with, I kind of understand a little bit, I guess. The release came pursuant to law, which requires a juvenile detainee who's detained to be tried within 21 days of detention, and the Commonwealth's attorneys requested continuance due to evidentiary issues. As part of the court's order, the assailant had to wear an extra electronic monitoring bracelet was not allowed to return to SBHS and could not use the computer. On July the 6th of 2021, the Court Services Unit notified the Superintendent's Office of pending charges against the assailant. This was done pursuant to law, which states that the intake officer shall file a report with the division superintendent of the school division in which any student who is the subject of petition alleging that such student who is a juvenile has committed an act wherever committed, which would be a crime if committed by an adult. The notification was the source of public squabble and subject of a series of letters between the school and the school district or the school officer. The school claims the sheriff's office never notified them of the offenses, as is required, which states that local law enforcement officers shall report on offenses wherever committed by students enrolled at a school if the offense would be felony if committed by an adult. But they didn't need to report it because they knew for a fact, but they're saying the sheriff's office didn't tell them. The police and the public schools and the sheriff's office knew within minutes of each other about the assault on May 28th, and they worked together at the high school that day to collect student statements and evidence. An offense occurs on the day of the incident, and there's no doubt the school was notified of the offense on May the 28th. A petition is a formal charging document for a juvenile. Under Virginia law, the intake officer, and not local law enforcement, is required to notify the superintendent of the petition, and this was in fact done in this incident. However, juvenile intake did not call the supervisor's office, email the superintendent's office, or send a copy of the notification through mail. Instead, the process at time was to send via inter-office envelope, which was picked up at the courthouse. Further, the envelope was addressed to David Spage, who is an employee of the school, but does not work in the superintendent's office since 2014. As a result, it's unclear what happened to the envelope once it was picked up at the courthouse, and there was no evidence to confirm receipt of notification. So they sent notification to the wrong person, even though they didn't need it because they already knew. So all those things. Due to privacy concerns, the inter-office envelope method of notification from the court services to the superintendent office had been the procedure for many years. During calendar 2021, there were 39 school notifications sent, but it's unknown how many of these the superintendent's office ever saw. On December the 7th, the head of court services unit met with the superintendent and chief of staff to discuss the procedure and clear up that notification process. I'm sure we're all feeling just thrilled and reassured by all those things. All right, the transfer. The process of transferring the student from SBHS to BRHS in summer 2021 encapsulates the lack of communication between entities and general lack of curiosity by certain individuals that ultimately allowed the October 6th assault to occur. In the ensuing weeks after the assailant was released from custody, the court services unit learned information from the assailant's family that caused them to keep a tight eye on the kid. The assailant's grandmother, whom he'd spent 2 weeks after being released from custody, called probation just to make sure they knew how bad things were. She also called the assailant a sociopath who does not care about consequences. So the grandmother is talking to the probation officer and has some concerns. The mother of the assailant pleaded with probation that she'd been begging for help from the school for years, only to have them enable his manipulative capabilities by siding with him and trying to be the fair and neutral party, often discounting the mother's approach and recommendations with respect to reasoning and actions. Only after his actions escalated to concerning levels did they choose to listen and incorporate the mom's input. Most recently, the SBHS principal and I had a conversation in his office after the May incident. After noting I tried all year to discuss my concerns and recommended approaches with multiple faculty and staff, did he say, "Now we are listening." I strongly encourage us not to wait until another escalation of events before buckling down, or else will be another statistic in the adult circuit instead of exploring the greater potential he holds. I'm thinking that he's going to spend some time in prison. In late July or early August 2021, the principal called the principal to alert him of the involuntary student transfer. The SBHS principal mentioned to the student he was facing a sexual assault charge and had a court order that did not allow him to return to the school. But the principal did not ask further questions about the nature of the charge or incident. So the one principal says sexual assault charge and court order, but the other principal's like, I don't need to know anything more beyond that. Okay. An involuntary transfer of a high school student requires a formal letter of the director of school. Even though the principal acknowledged it was unusual for a court to order a school student not to return to a particular school, rather than follow up the phone call with the principal decided to wait to hear from the director. The school year began on August 26, 2021. It was not until the day the superintendent's office learned the assailant was prohibited from returning to the school. The court services unit tried to alert the new school of the court order that the student could not return to the old school. On August the 24th, the probation officer reached out to the assistant principal, alerting him that the student could not return, and made himself available to discuss a plan to ensure the individual could not be an active student within the school. By the following day, he had not heard back, which concerned the probation officer, since the school would need to be clued in about several aspects of the court order, which include electronic monitoring and students' prohibition of computer access. After talking with the assailant's mother, the director of school administration talked with the probation officer, and on August 26th, finally received a copy of the court order. This formally spurned the transfer process, with the director providing a letter officially placing the student at BRHS. The director of school administration spoke with the BRHS principal and told him the student was being transferred and had some accompanying legal charges. Yes, just a few. It's unclear on what date the student started at BRHS, but was sometime during the week of August the 30th. After receiving the formal transfer letter, the principal had multiple conversations with the probation officer, who was on heightened alert about the incoming student and logistics surrounding the transfer. The principal was aware the student was wearing an ankle monitor and was the only student at the school doing so. The principal knew the student was charged with sexual assault and sodomy, which he knew to be felonies, but he did not look at the student's incoming disciplinary file. So he didn't review his entire disciplinary history, because why would that be important? The school principal also set up a meeting with the incoming student, his mother, and assistant principal. School principal said there were going to be check-ins with the student, and there'd be some heightened, some sort of helping with the transition plus also monitoring. The assistant principal told us the principal never told him the student was wearing an ankle monitor or had pending assault charges. The principal, however, did share that information with the school resource officer. Despite the court requirement that the assailant not return to SBHS, the Commonwealth's attorney did not reach out to LCPS about the requirement to ensure it had been followed. In addition, the Commonwealth's attorney was unaware of the transfer until October 6th assault that occurred. So somehow, the Commonwealth's attorney didn't know about any of this either. An individual from the office testified, to be perfectly frank, when I was agreeing to release him and put him in a condition he would not return to Stone Bridge, it was my belief the school would take some action because that just seems logical. He's on the radar, right? Apparently not. It is our considered judgment that the October 6, 2021 sexual assault at BRHS never should have occurred. Had any one of a number of individuals across a variety of entities spoken up or realized a serious problem was brewing regarding earlier incidences at BRHS, then the assault most likely would not have occurred, but no one spoke up. Shortly after the school year began, the transfer student quickly began causing issues at the school. He enrolled in a graphic design class, but due to court order, he was unable to use a computer. That makes it a little bit hard to do graphic design. His art teacher quickly recognized the untenable nature of the situation and problems it created in the classroom, so he talked to the principal about it. The principal told him he was awaiting approval from the judge to be able to use a computer at school, but didn't share anything more. The art teacher didn't inquire further, saying that they trusted administration was doing the job. Shortly thereafter, the art teacher again spoke with the principal. 2 female students had approached her, telling her the transfer student had made her feel uncomfortable by the way he was behaving. He had discovered where their friend group was hanging out and was following them places, apparently everywhere they were. The 2 female students asked to be moved away from them in class. The art teacher decided to create a new seating arrangement, complying with this request so it would not draw attention to the situation. The art teacher subsequently told the principal about this entire situation, and in case anything like that occurred in other classes or anything I wasn't aware of. The high school principal simply approved of her plan and said that they were going to check in with the student. On September the 9th of 2021, during English class, the transfer student made some inappropriate sexual comments to a female student. He grabbed the student's shoulder really hard, attempted to take her Chromebook, and repeatedly tapped on her head with a pencil. He also asked if she had ever posted nude photos of herself online, and asked another boy in class if his grandmother's nudes were posted online. The assistant principal reported this incident to the superintendent's chief of staff, the Title IX coordinator, for possible Title IX violation for sexual harassment. The chief of staff determined the offense did not meet the threshold for a Title IX violation, and the school would investigate and adjudicate under its own code of conduct. The chief of staff learned this was the same student who had committed assault at the high school. The chief of staff then spoke with the superintendent about the issue, and while both expressed concern, there is no evidence of any discernible action. So, like, things are going about as well as you'd want, but no one is doing anything. The director of school administration was alarmed at learning of this incident and had a conversation about it with the deputy superintendent, who said obviously it was very upsetting. She called it disturbing. She testified she certainly would have alerted the chief of staff and superintendent about it. Every evidence indicates both the superintendent and chief of staff learned of the incident from multiple people. The director of the school administration and deputy superintendent also did nothing about the situation, despite their concern. Discipline for this incident therefore fell upon the school's principal. He spoke about the incident with the probation officer, who was concerned about the ongoing bizarre behavior by the student, and shared his concerns with the principal about how the student would think his behavior is all right, especially with the current court and school situation. The principal did not review the student's disciplinary file, which he called significant after reviewing it months later, and testified that there was some slight discrepancy in the student's statements. I bet there was. He felt a verbal reprimand and phone call was sufficient. How you reach that conclusion, I don't know. How you reach that conclusion, I don't know. The only additional discipline was for a student to write on a piece of paper to not commit such conduct again. Just a friendly reminder to those people in chat, we don't allow insults to other people in chat. You're allowed to disagree with each other. Don't insult other people in chat. It is a rule. It's a rule in the okay. I don't need to go into detail. Okay, where was I? The probation officer texted the Commonwealth's Attorney's Office about the incident. And even though the deputy's Commonwealth's attorney testified he does not recall learning of the incident, other testimony indicates he had a conversation with the probation officer at about this time. The high school's school resource officer learned of the incident the following week when the assistant principal told him about it. In addition, the detective investigating the high school's sexual assault, who learned about the incident from the school's probation officer, called him to inform the school resource officer about the sexual harassment. The school resource officer wrote up a formal report and submitted it through the normal process for all the good it's doing anyone. The most senior individuals in the school knew of the incident and knew it was the same person who had committed the other sexual assault. Multiple people in the school were aware of this incident around the time it occurred and knew it was the same person who had committed the sexual assault. The deputy's Commonwealth's attorney prosecuting the case knew of the incident and the probation officer, who had been communicating with the student and family nearly a day for over a month, and knew of the incident. Not a single person with knowledge of the student's history or of this current action stepped in to do anything. Instead, discipline was left to the principal, who did nothing more than the verbal reprimand. It feels like the school had plenty of red flags. It feels like there are many, many red flags to go around, and people are just not doing the red flags, and it is not going very, very great, to be honest. Yeah. Yeah. Okay. On October the 5th of 2021, the assailant, that would be the trans student, sent a cryptic message to a female student on her school computer, which is kind of odd since he's not allowed to use a computer now, is he? The cryptic message was not seen until 2 days later. Shortly after the cryptic message was sent, the assailant followed the female student and her friend in the hallway. The girls began running down the hallway away from the assailant and into a female restroom to get away from him. The assailant sat outside the restroom waiting for him. The girls eventually exited the restroom and ran in the other direction from where the assailant was sitting. The following day, after math class, the assailant asked the female student to walk him to his next class, which she did. Along the way, he stopped outside a different classroom and peered in to find it unoccupied. Video shows the assailant waiting for a group of students to walk by. Then he put his arm around the female student's neck, abducted her into the classroom, and closed the door. Once inside the classroom, the assailant put a chokehold on the female student to the point where she could not breathe, and then raped her. Upon leaving the classroom, the female student went into the classroom, where she met a friend and told her what happened. The girls left the restroom and saw the principal in nearly an empty hallway, where he was working from a mobile standing desk. Instead of telling him what just happened, they adjusted their masks above their noses and kept walking. They subsequently went to the main office where they reported the incident to the police officer. So they didn't tell the principal, but they told the police officer. They told the police officer, "I'd just been raped." Later that day, the juvenile intake issued a detention order and 2 petitions for abduction and sexual battery. It's unclear why the more serious charge of abduction with intent to defile was not considered. The assailant was taken into custody that afternoon, where he's remained ever since. The victim has spent her freshman year of high school remotely, so the 2021-22 school year was her first real experience with high school. Just more than a month into school, as the victim's father testified, a sexual assault upended her life and life of her family, had financial impact, and created untold stress for an event that will affect her mental well-being and stay with her for a lifetime. It very well might. Though the principal testified he cares very much about the victim, he has also acknowledged he's never spoken to her about the incident, and father testified he would have expected probably more interaction from the principal. Later in a call with the director of the school administration, the principal simply said, "The placement didn't work." Wow. Wow. I mean, that's certainly one way of putting it, my friends. That's certainly one way of putting it. The placement didn't work. That is certainly a conclusion we could come to under these operative facts. Wow. That's just brilliant work. Wow. I just round of applause all the way around, guys. Just going great. The fallout. On October the 7th, the Director of Safety and Security emailed the Chief of Staff stating, per our convo, a student was arrested yesterday at Broad Run High School and charged with abduction and sexual assault. Student allegedly forced a female student into a room and assaulted her. The Chief of Staff forwarded this email to the superintendent saying, Title IX out of Broad Run, I'll brief you later. At 10:35, the Chief of Staff sent an email to the entire school, copying the superintendent, deputy superintendent, and director of communications saying, good morning, board members. Please draw your attention to the email below. I've been advised the school may be planning a press release today regarding this incident. We keep you informed as additional information becomes available. The director of communication responded to the email later that afternoon with a statement from the officer and statement from the principal. Nothing in any of the emails indicated that the transgender assailant was the same individual who committed the other assailants in May. On October the 8th, Luke Rosnack from Daily Wire emailed the public information officer about the following. I'm prepared to report that this student is the same student who was criminally charged after a similar allegation about a girl's bathroom at Stone Ridge in March. Why was the student permitted to be in LCPS, and why was he moved from Stonebridge to Broad Run? Has Stonebridge ever reported the May alleged sexual assault in any statistic or made anyone aware of it? In a school-wide email sent by the school principal that day, he appears to instead present the alleged victim's father as a threat while concealing the underlying incident. So Daily Wire over here doing yeoman's work, the only one actually bothering to inquire about shit. While I understand and respect the need for privacy around certain details, there are major public safety and policy issues raised by this and significant public interest. If you contend that any of the facts I lay out are erroneous, I'll need you to provide me supporting evidence as soon as possible today. The public information officer forwarded the email to the Director of Communications, Director of High School Education, Chief of Schools, and Deputy Superintendent. The Director of Communications responded to the public information officer, saying, for your information, I've worked with Division Counsel and will handle. No further action and enjoy your day. She followed up minutes later to the group email saying, team, take no action. I've got this. Thanks. We do not have any evidence that she or any other employee informed anyone on the school board about the impending article. 3 days later, the Daily Wire published an article stating the HBHS assailant and the BRHS assailant were one and the same. Each school board member was stated they first learned about this connection from the press reports and not from the school employees. Their reactions, irrespective of political ideology, were universally negative. School board members were angry, blindsided, expressed disgust at the situation, saying it's horrific. One member asked, why are we left out? And why were we not made aware as soon as the second one happened? One board member emailed the superintendent saying, we urgently need some background here. Please give us a high-level summary via email. On October the 12th, excuse me one second. By the way, just a friendly reminder, if you're not already subscribed, just check your friendly subscribe button. We're right on the brisk of 122. So if you could just check your subscribe button and see if you are subscribed. Even if you think you're subscribed, why not check again? Because maybe you've become unsubscribed while we've been talking. I don't know. YouTube does some weird stuff. And why not also like the video? That also helps. And you see the people with the cool little scale icons by their name? They're members of the channel. You can become a member of the channel too by hitting that join button or hitting the link in the description or any of those things. So do those things and let's read some more. On October the 12th, the school board held a closed session wherein The superintendent and division council provided an update to the situation. Following the closed session was a heated period of public comment, with much anger and ire directed at the board, with many calls for resignation. While we understand the public's confusion, frustration, and anger at this time, we see no evidence that the school board as a body or any of its individual members knew anything of the events outside the May 28th email the superintendent sent. So this was being kept outside the board's attention by the administrators who didn't want to gain their ire. The following day, on October 13th, the school put out a public statement trying to tamp down public anger. The statement defended the school's actions, stating that the school is prohibited from disciplining any student without following Title IX grievance process. That's some bullshit. The school has complied and continues to comply with its obligation under Title IX. Nowhere did the statement express any grief or remorse toward the victims of either of the sexual assaults. Thank you, JoJo, for the 10 gift memberships. It is very, very appreciated, by the way. Thank you very, very much. Are alerts coming up on screen? Yes, they are. I've seen them. There they are. Okay. I want to make sure that was working. Okay. On October the 15th, the superintendent held a press conference outside the school administration building. He read a prepared statement and did not take any questions. The statement, written with input from Donovan Group, a school district communication, marketing, and public relations firm, contained numerous critical inaccuracies. The superintendent stated that throughout the events, the Loudoun County Public Schools has complied with their obligations under Title IX. Mobile witnesses with Title IX expertise said not so much. The superintendent also stated that lack of oversight that existed prior to tenure also contributed to errors in our state reporting regarding discipline incidents at the school. Multiple witnesses testified the error in reporting, where the school did not include the incident in its discipline, crime, and violence report to the Virginia Department of Education. A fact they just learned October 14th via email occurred under the superintendent's tenure, so they didn't report it as required to the Virginia Department of Education. The superintendent also stated that board member Bartz asked a question about discipline incidents in bathrooms that I wrongly interpret as incident involving transgender and gender fluid students. I did this because I was viewing the question in light of the general questions and debate the board was participating in and around Policy 8040. As we write in this report, the superintendent knew mere hours before the sexual assault took place it related to Policy 8040, yet never related this to the board. On October the 21st, the school released another statement regarding the email from the superintendent to the board. This was the first time the public learned the board or the superintendent had any awareness of any events as they were occurring. The statement was released to provide good context because May 28, 2021 email was being released not voluntarily, but pursuant to Freedom of Information Act. Lol. Always trying to hide behind something. In late October 2021, the school board agreed to the commission that an investigation into the events surrounding the assaults should occur. This was not publicly announced, however, until over a week later on November 5th. In the statement, the superintendent said that they had hired a law firm to conduct the independent review of these incidences. Please know this independent review is only one step in moving forward to helping the school. We will keep you up to date about the steps we take. So that's why they hired a law school to try to keep the whole law firm to try to keep the whole thing privileged. That's clever. That's why they hired a law firm to conduct the investigation, so the whole thing would be privileged. Very, very cute. Although the statement did not state the independent review would be released publicly, many witnesses, including several board members and senior administrators, testified they assumed the report would be made public, albeit with necessary redactions. One school board member acknowledged that as a parent, I'd want to read the report. Many board members were surprised to learn the report would be subject to attorney-client privilege. Based on the testimony presented, we believe the school board were unaware this report would not be made public at the time they agreed to conduct the outside investigation. Several board members testified they were only given half an hour to read the report and ask questions. Despite having asked for the review in the first place, they were handed out numbered copies and required to return it upon leaving the room. On January the 14th of 2022, the board issued a public statement saying the report would not be released, listing attorney-client privilege as the third and least important reason. The statement also noted several changes. Attorney-client privilege is bullshit because they can waive the privilege, right? Because of the school board, right? So they can waive the privilege. But so that's just total bullshit. The grand jury now writes, "We are concerned at the lack of interest by senior school officials regarding the contents of this report. Several changes were apparently implemented due to independent review, yet no senior officials, when testifying, questioned why any of these changes were taking place or whether they were even necessary. For few, if any, senior officials had any interest in what the independent review concluded. Notably, the deputy superintendent, who oversees school discipline and student instruction, testified that she had no interest in reading it. We attribute this lack of curiosity and attachment to staying in their silos, to a culture of fear permeating the school, a culture where anyone speaking up or daring to step out of place face some sort of reprimand. Why isn't your name green, Jenna? Because your membership has expired. But not to fret, you can gain that membership back for a mere 99 cents a month. It's literally the least YouTube will let me charge you. You too can become an uncivilian and a member of the channel. It's true. All you have to do is hit that beautiful, beautiful join button. And if you don't see a join button, all you have to do is click the link in the video description or click the link that the bot tells you about from time to time. It's literally just the channel name /join, by the way, as well. So you can just go to youtube.com/@uncivillaw/join, and that also works. Any of those options are great. And for 99 cents, you can become an uncivilian, get your name back in green, get those scales, and help to support the channel. Let's resume our reading. Title 9. But if they waived that privilege, wouldn't that subject to a lawsuit? Probably not. No. Because qualified immunity. Right. Probably not. I mean, someone will sue them. They could sue them anyway. But, like, they all have qualified immunity. So I mean, I wouldn't, yeah. Title 9 is a complicated federal law that few people, if any, fully understand. We believe the school was severely delinquent. If you send me a Pooh Bear or stuffed kingpin, can you get a green check mark? Sadly, no. Your only way of getting check marks, your only way of getting the green is by becoming a member. But you're also free to send me stuff if you like. I do have a post office box. We believe the school was severely delinquent with its Title 9 responsibilities, and due to Title 9 complexity and the public's lack of familiarity, has used Title 9 as a shield to fend off criticism for lack of action regarding this assault. In several public statements since October 6th assault, especially in the immediate aftermath, the school board, and representatives of those entities have been steadfast in stating the school will comply with its obligations under Title 9. Even a cursory review of the documents and testimony, however, reveals these statements are far from the truth. Behind the scenes, the Title 9 procedures were essentially non-existent, staff was inexperienced, senior officers squabbled, and the superintendent was aware of it all. One witness best summed it up by saying, "We did not have a process in place." After the May 28, 2021 assault, the school made little effort to begin a Title 9 investigation for months. In fact, the Title 9 investigation did not begin until October the 19th of 2021, an indefensible delay of nearly 5 months. School officials claimed this was because they were not permitted to begin their investigation until law enforcement concluded theirs. However, no witness who testified was able to identify a single law, statute, policy, or agreement that made this true. And there is the link right now from Streamlabs. If you want to click on that to become a member, there's the link. Should hopefully direct you to the right spot. The school's Title 9 coordinator in 2021 served concurrently as chief of staff and reported directly to the superintendent, who was the previous Title IX coordinator. The chief of staff reportedly testified they needed the charges from law enforcement to move forward with Title IX investigation because until he had this information, it was just an allegation of attempted assault, which was not enough to begin an investigation. Yes, it really is. Yes, it really is. The district of the school administration disregarded the assessment, and in conversations with the chief of staff about it in July and August, the director, even though his office was not supposed to be doing Title IX, also created a Google document of possible Title IX violations reported from schools because he's worried at the time they were not reporting some things that could become Title IX. In a series of emails, the director repeatedly told the chief of staff, the school, thank you for the gift memberships, Chameleon, that's very, very kind of you. In a series of emails, the director repeatedly told the chief of staff that it needed to begin an investigation into the assault. Not making any progress, the chief of staff regarding the assault, the director of school administration took his frustration straight to the superintendent. Shortly before the 2021-2022 school year began, the director spoke with the superintendent about the situation. The director testified the superintendent alpha dogged him down, meaning the big dog spoke, so you back down a little bit. You understand what they're doing. On September the 17th of 2021, the director of school administration testified that he emailed the superintendent, chief of staff, deputy superintendent, and chief of school about the situation. He testified the email laid out his extensive training, experts he had met with, and the fact that SBHS assaults should be immediately automatically triggered for an investigation. It's unknown how the superintendent or these officers responded. The school refused to provide us this email, but it was not until a month later after the assault that a Title IX investigation into the assault was opened. The individual who ultimately conducted that email investigation testified it was the first Title IX investigation that she had ever done. Thank you, alarm clock rings. That's very nice. The chief of staff testified that he could not begin a Title IX investigation until he learned the official charges from law enforcement. Until that point, it was just a school-related disciplinary matter. This contrasts sharply with public statements stating that the school is prohibited from disciplining students until Title IX grievance process was followed. Either way, no school discipline took place following the assault, thus allowing the student to transfer after confinement over the summer. Multiple witnesses testified the chief of staff was fired due to the lack of action regarding Title IX in this period. It's important to point out the lack of cooperation between the school and the sheriff was an underlying issue throughout the summer. This unquestionably contributed to the school's delinquency in opening the Title IX investigation into the assault. Though the charging of the assailant in early July should have been enough for the chief of staff, under his interpretation, to launch the Title IX investigation, the sheriff refused to provide the actual charges to the school. Juvenile intake, though, had already informed the school of the charges through procedure they had in place described above, so the school should have known what the charges were. The school, however, did not receive its notification due to outdated notification procedures because of the whole school envelope thing. You're not boring me, Mr. Hellspawn. You're not boring me. Thank you all for being here. On August the 13th of 2021, the director of school administration sent an email to the school officer, to the sheriff's officer and other officials stating, "Can you get together to establish procedures for the alleged sexual assaults that occur under the school's jurisdiction? We have learned that we have extensive Title IX federal regulation that are required in cases involving student or staff when it comes to reporting sexual harassment or assault. Federal regulations require we start our process immediately. Can we get together to establish steps so we're in compliance with federal law while law enforcement begins its investigation? Aren't teachers and TAs mandatory reporters? Sure. But it's not clear that they didn't do that, to be honest. But maybe they didn't. I don't know. Meetings followed on August 17th and September 29th, and through the two parties' cooperation regarding the sexual assault, law enforcement still refused to provide information to the school regarding the May assault. On October the 14th, amid national scrutiny, the chief of staff provided the superintendent update on these things. Thank you. I need an additional 9 subscribers, by the way, for those of you who are interested in such things. So if 9 of you who haven't subscribed would like to, that would be fine. And just in terms of providing growth to the channel. The special grand jury highlights the lack of cooperation from the school and the majority of the board members throughout the investigation. We expect these public servants to provide clarity, transparency, and willingness to report truthfully. Yeah, right. Instead, we are met with obfuscation, deflection, and obvious legal strategies designed to frustrate the special grand jury's work. Yeah. I'm not truffle shuffling. I already have enough self-image problems as it is. On April the 7th of 2022, the first act of the special grand jury was to authorize subpoenas for the superintendent and chairman of the board. Though the school publicly declared in April 13th statement its intent to cooperate with lawful requests of the special grand jury, we experienced a much different posture behind closed doors. I bet they did. From the outset, the school board put up roadblocks to obstruct our investigation. On April the 14th, the chairman and superintendent, both represented by the same attorney, submitted a motion to quash the subpoena, claiming that among other reasons they were invalid on their face, and the office of the attorney general was exceeding its authority. The court rejected those arguments. Yeah, it sounds like they're cooperating. 6 days later, an elementary school principal, represented by the same attorney, filed a motion to quash using the same arguments the court again rejected. On April 22nd, the same attorney filed another motion to quash testimony on behalf of 3 teachers using the same argument. Those were rejected. In this instance, however, one of the teachers was explicitly not represented by the attorney, even though he claimed to the court in a filing that he did represent her and was advocating on her behalf. The teacher said she felt pressured by the attorney into representing her. The teacher told her not to provide the special grand jury with anything, and the attorney tried to shut her up because this won't work well for the school. So the attorney says he's representing her, and the teacher's like, no, you're not. No, you're not. That's how much they want to cooperate with this. She also said she had received an email from her principal, the first one she'd ever received from him, asking her to call division counsel for the school, whom she characterized as alarmed and distraught. On May the 20th, the school board filed a complaint in civil court seeking an injunction against the special grand jury. The complaint recycled most of the same arguments previously rejected by the court, but due to the sealed nature of the rulings, the public was unaware these arguments had already been rejected. Similar to the motions to quash, the court denied these motions for injunctive relief. In June, the special grand jury issued subpoena to 2 board members to testify. True to form, the school council filed a motion to quash. On the date of the testimony, the 2 school board members did not show up. The court gave them 2 hours to arrive at the courthouse, otherwise the court would issue a warrant for arrest. The board members subsequently arrived in a timely manner. One school board member testified it was based on counsel's advice not to show up, otherwise they would have been there. Nice. The conspiracy goes wide and deep, my friends, wide and deep. I still need 6 more subscriptions, by the way. So my call for subscriptions wasn't really working, I guess. Throughout the investigation, we felt counsel was obstructionist during Witness testimony. The relevant code allows for the presence of counsel for special grand jury witnesses and states that such counsel shall have the right to consult with and advise the witness during examination, but shall not have the right to conduct examination. Counsel consistently and repeatedly interrupted answers of his own witnesses when he felt certain information was about to be revealed. Counsel consistently and repeatedly objected to questions that would elicit information about meeting or conversations that occurred when division counsel was present, regardless of whether the meeting or conversation had anything to do with soliciting legal advice or if division counsel was even a party to the conversation. Not an uncommon tactic, by the way. Let's have an attorney present and claim the entire thing as attorney-client privilege, which doesn't really work. But some people are still trying it, right? Some people are still trying it. It's a way to be obstructionist. Division counsel's mere silence present in a crowded room was enough for the lawyer to claim attorney-client privilege and instruct witnesses not to answer. As the investigation continued, counsel objected to certain questions, even though he allowed previous witnesses to answer the exact same question. Counsel also inappropriately used hand signals and other methods to communicate with witnesses while they're testifying. We believe division counsel was trying to control the flow of information to the special grand jury by using position as division counsel to exert control and influence over the individual testify. Incidentally, not all grand juries and all grand jury proceedings allow an attorney to be present. But apparently this one does by its operative rules. So, you know. We also received testimony from one school board member that division counsel blew a gasket when the school board member informed him he did not need a lawyer, yet alone a lawyer of division counsel's choosing. We received the May 28, 2021 email from the police, from the school chief operating officer regarding policy 8040 and the incident early September, even though it should have been produced months earlier in response to subpoena to the superintendent. Instead, this mail was produced pursuant to document subpoena to a different administrator who had their own lawyer and not the preferred lawyer at division counsel. Nice. Division counsel soon learned that we had this email. Multiple school board members testified division counsel had alerted them to this specific email once they realized we had it. The school board members also testified division counsel had not previously shared with them other documents produced to the special grand jury. In other words, this was a unique case. Thank you, Laura, by the way, for your gift memberships. That's very nice of you. Don't forget to join. It's only 99 cents. Several school board members testified the exact same story. The chief operating officer said the incident at the school had to do with policy 8040 because the father of the victim who showed up that day was shouting about policy 8040. There's absolutely no evidence the father said anything about policy 8040 that day or that he even knew what the policy was that day. No school board member could provide any evidence that what they claimed happened had in fact happened, even they all parroted the same story. Interestingly, multiple school board members also corrected special counsel to the special grand jury. When asked about individual wearing a skirt in the female bathroom this day, these school board members were quick to claim that he was instead wearing a kilt. I'm sure. We strongly believe these stories come from the school board members as an effort by division counsel to get everyone on the same page, to thwart, discredit, and push against this investigation and this report, and promote their own narrative. Of course, their narrative is completely undermined and contradicted by sworn testimony of the chief operating officer cited above, who wrote the email concerning policy 8040. Since the chief operating officer appeared with his own lawyer, neither division counsel nor the school board's lawyer was privy to the testimony. Unlike Virginia law, no Virginia statute explicitly addresses witness tampering, and Virginia obstruction of justice statute does not cover this fact pattern. For those reasons, we're unable to consider an indictment against division counsel. Wow. So the grand jury is completely thwarted. There's no federal statute addressing witness tampering, really, in Virginia? And the obstruction of justice doesn't cover it, so they can't bring indictments. Wow. No wonder there's no disincentive to cooperate. So now we have some recommendations. We're including the following recommendations. To increase transparency and foster better communications. Why would they do that? The school should include as much information as reasonably possible when informing parents, staff, students, and community about significant incidents occurring on school property, on a school bus, or a school-sponsored event. I'd read the rest of the recommendations, but does it really matter? Because why would the school do any of these things? So there's some recommendations in there, but we'll ignore that. Although the school has taken some positive steps forward resulting from the sexual assault, such an increasing resource for Title IX compliance and updating the policy. Throughout this investigation, we've learned the school as an organization tend to avoid managing difficult situations by not addressing them. Whether they're intended or not, this practice conveys to the public a sense of apathy. This has not served them or our community well, and the culture needs to change. Stronger leadership would address problems head on instead of letting them snowball. As 9 members of this community, we're certain public would reward their leadership. I doubt that very much. And then there's attachments of some exhibits and stuff showing some emails and things. We'll just some emails showing their attempt to meet up for some sex time, which apparently is a thing that happens at this school. Some handwritten notes. Schools. Yeah, okay, great. So all those things. So yeah, that brings us to the end of that stream, I suppose. And we need 2 more subs. Can I get 2 of you sub? Two subscriptions. 2 people hit that subscribe button who haven't done so already. These kids need lives, yeah. I think so. So at least the stream worked. And is it working on all the platforms? Let's see. Let me check my Facebook. Is it streaming there? Yes, I am streaming on Facebook. Yay. Am I streaming on Twitch? Hold on. I think I saw some bits, but I want to actually manually check. Yes, I'm streaming on Twitch too. Excellent. So I'm streaming on Facebook and Twitch and YouTube all at the same time. Great. And if we ever get a single stream key for Rumble, we will absolutely simul stream with Rumble as well, because I don't want to set it up for every stream individually. But if we get a single stream key like these all do, then I will be happy to do that too. So that's awesome. I'm happy the technical is kind of working. That we got the alerts on screen. We got the alerts on screen, and we got the camera on screen, and we fixed the color temperature problems in the camera. The color temperature was off on the camera. So I had to fix that. Shift by quite a bit. I think it was at 5500 Kelvin, and I shifted it to 3900 Kelvin. Just in case you're curious about such things. So yeah. Annabelle gives $49.99. Well, thank you very much for your lemon dancing. That's a very, very generous lemon dancing. Thank you very much for that very, very generous super chat. The real question is, how much longer will these streams be available for? Indefinitely. I only tend to delete streams when they go shit. The only time I delete streams is if the stream itself goes bad for technical problems. So like some errors I'm willing to work through and some errors not, right? I do take this somewhat professionally and somewhat seriously. So, you know, we're doing it live and I'm producing my own content. And so there's a lot of things to focus on at once. So I make mistakes. Some of those mistakes I will press through and some I won't. It depends how catastrophic the mistake is or how catastrophic the series of mistakes is, right? So I only delete streams for that reason. And then the only other time I hide streams or disable streams is when I'm doing batch records. Although I've been playing with that and not doing that incident all the time either. Because when I do batch records, I'm recording stories for later daily releases. And I want to, after recording them, then no point in being the stream being available. And also it would take away from the impact of the stories. So yeah, those are really the only situations in which I delete or hide a stream. Because the stream went to shit, or because it was a batch record. So that's, yeah, basically when that happens. Still, okay, let me see on the back end about, or I accidentally schedule 4 streams at the same time, which I guess falls into the technical problems category. Today we had $20 from Adam Tapp, who said, "You're beautiful no matter what they say. Lol, it's fine." Thank you, Adam. That was very kind of you. $2 from Melinda, then $2 from Melinda. $9.99 from Freda Lee. $5 from Bad Weather Biker, who said, "Amazing how believe all women becomes blame the victim by people like Veronica when a troon is the perp. Hashtag so much progress." Adam Trapp says, $20. "Every time you say trans, Veronica loses her mind. Please keep going." $4.99 from Joshua says, "How hard is it to sue a school on something like this?" Very hard, because qualified immunity. "I feel like a private company, they have policy discretion. Qualified immunity is your problem." Joseph gives $4.99, says, "Love what you do at Uncivil. Isn't this some Title IX BS? Can't we just look it up and read it, or actual policies in conflict?" It's not clear they had a policy of anything. Quitcha Bitchin gives $9.99, say, "Thanks for covering this. Sometimes these things get swept away to the hidden unknown. There's true obscene in handling. Hugs to you." Lisa White says, "How do I gift subs? Don't see how." You gift subs as a super chat. So you go to the super chat, the $ feature, you hit the $, and instead of super chat, it says gift memberships. And that's how you gift memberships if you want to do that. And $25 from Dragon's Flight, who said, "I actually caught a live stream. Great to see you, Kurt." Well, thank you very much. That's very, very kind of you. I appreciate it. Qualified immunity should be abolished, either that or radically constrained. One of the two. I tend to agree with you. I did go to the gym today, by the way. I wasn't in there very long, but I did make it, which is a plus. I did 3 exercises today, and then I did 10 minutes in the sauna. That's amateur numbers, but I did do something for myself today. So, small victories. What do I think about self-defense for girls in school? The same thing I think about self-defense for everyone in school. Everyone has an inalienable right to self-defense. And I don't think that changes one way or another. Can I get 2 more subs? I'd like to end this thing at 122. You did your makeup today? That's where you're about? That's cool. That's something. That's a thing. You did a thing today. Peter says, "Fine, let me be one." Thank you, Peter. I'd say it's more important you do it regularly. I agree. I agree. Trying to make it a regular habit. I go to the gym 3 days this week, so I suppose that's progress. You walked to the pharmacy and back today? Hey, that's walking. That's plus. As a lawyer, do I think there's any legal argument for the bathroom policies to be in place? Sure, there's legal arguments. I mean, it ultimately boils down to policy arguments, to be real. I mean, what are your policies that you want? The real arguments are policy, not real legal. But yeah, sure. Laura gives 5 additional gift memberships. Thank you very, very much, Laura, for those 5 gift memberships. Just remember, you too can become a member of the channel. It's only 99 cents. by hitting that join button. The link from Streamlabs is just a couple links above, and it's also just youtube.com/@uncivillaw/join. Okay, we crossed the threshold. 122, baby. We crossed it. Woo! Woo! We crossed the 122 barrier. Oh yeah. We crossed the 122 barrier. Oh yeah. Oh yeah, yeah, yeah. Woo! Cool. I will take the victory. I will take the victory. We are the champions, my friends. Dun, dun. We'll keep on fighting to the end. Dun, 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 dun. We are the champions. We are the champions. No time for losers. We are the champions of the world. Woo! Awesome. You guys put me in good spirits. You guys put me in good spirits. I paid my dues time after time. Y'all know really, y'all been no crime. Oh man, no, it's good. I'm gonna try to do some batch recording tomorrow, and yeah, and I haven't been streaming as much this week. Do Prince one again? It's 2000 parties over, oops, out of time. But we're gonna party like it's 1999. Hey, 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 1999. Yeah, so we'll try to do some batch record tomorrow, and we'll also try to stream more in the upcoming week. We'll see what's gonna happen there, so all that good stuff. All right, I guess that will bring us to the end of the stream then. If you've been liking the stream, don't forget to do all the YouTubey things, like, comment, subscribe, all the rest of it. I really do appreciate everyone who's here and helps to help the channel grow. And thank you everyone, by the way, for all your encouragements relating to depression and stuff. It does help sometimes. It does help, and helps me grow and remember that I'm, you know, doing something of some value. So I do appreciate it. So all that good stuff. I've been Uncivil Law. Until later, my friends, I hope all is truly well. Thank you, my friends, and goodbye.